Well, welcome to the Subro Scoop. My name is Tiffani Palmer, and I'm a partner at Weltman, Weinberg & Reese. I've been with Weltman since January of 2016, and I have practiced exclusively in the area of subrogation. By the way, a very quick background. I started off as a claims adjuster for a national insurance company. Then after that point, I went to law school. Then after that, I started doing plaintiff's work. So I actually used to sue insurance companies on a regular basis. So I make a joke that I know everybody who knows me is tired of hearing, that I used to sue the insurance companies. Now I'm on the other side. I'm on the good side. And then now I'm just going to let Tom take a second to introduce himself.
Hello, everybody. My name is Tom Duquette. I am an attorney here at Weltman. Been at Weltman for about 3 years now. Spent most of my career as a collection attorney. Like Tiffani, I also did do some plaintiff work in the Michigan no-fault area. Also sued insurance companies, but I'm back on the good side now and happy to be doing another Subro Scoop.
Great, Tom. Yes. And so you can go to the next slide here. So we are thrilled to have you back for another episode of our webinar series featuring attorneys such as Tom and shareholders as myself from Weltman offices. Our episode today will cover litigation and collection strategies that work in the subrogation industry. But before we get started, I'd like to take a moment to go over a few housekeeping items. As a reminder, this is an interactive session, so please submit your questions through the question button in the control panel. Questions will be addressed during the presentation where applicable. And we did have a few questions that were presented before the actual presentation, so we're going to integrate those in. And so we appreciate you all coming up with questions beforehand, but don't let that discourage you. If you have more, feel free to shoot them away. At the conclusion of today's session, a link to the recording and a copy of the presentation slides will be sent to all attendees. Also, there will be a quick survey on your screen at the conclusion of the event. Please take the survey and share your feedback. I want to stress more that we really appreciate you doing that, and we love to hear your feedback, opinions, and how we can make our webinars better. So with that, let's go ahead and get started. And what is a presentation without encountering a little bit of technical difficulty? But Tom and I are so familiar with Uninsured. If we don't have a PowerPoint to show you, we're just going to just talk you to death for a whole hour.
That's right. We don't need any slides.
Okay, there we go. See? And let's see if we can make this larger. It's fun to see the PowerPoint frame, but we want to make this a little bit bigger. I know I have my glasses on, but everybody may not have their glasses on. So let's see if we can get that part worked out for you. Okay. All righty. Well, let's go ahead on into our poll question, and it's up here right now. I'll let you all read it. Take the time to read that. Okay, so case by case is still kind of leading the pack. And make sure everybody gets a chance to vote there. So yeah, it looks like case by case wins the day. And that question may have been, that poll question may have been a little bit too easy. We may have been leading to the answer there. But I want to thank everyone for participating that did. It was interesting to see the distribution regardless of what you actually selected. There isn't a single consistent approach to uninsured subrogation. Some organizations may pursue it aggressively, others rarely, and many fall somewhere in between. But today isn't about convincing you to pursue every uninsured claim. In fact, I don't think you should. Instead, I want to challenge the question we're asking today. Too often, the decision begins and ends with one fact. The defendant is uninsured, and what is wrong with stopping at that point? We don't want to stop just because they're uninsured. Uninsured does not mean unrecoverable. And so we have our objectives for today. And today, I hope that we rise. So by the end of this presentation, I'm hoping that we can recognize recovery opportunities, and we're going to identify, oh, we're really having technical difficulties, so bear with us. And sometimes you have backup. I'm going to show you all my backup. You have little old school paper. So just in case you don't have a PowerPoint or your technology doesn't work for you, you have old school paper that you can rely on. So today, regardless of the presentation, we are going to rise. So we are going to recognize our recovery opportunities through the life cycle of our uninsured subrogation claim. And we'll talk about what it means to be the life cycle of the subrogation claim. We are going to identify how pre-suit resolution efforts and strategic litigation, along with post-judgment collection, can create successful recoveries. We're going to strengthen your understanding of the recovery life cycle and the role each phase plays in maximizing recovery opportunities. And last, we're going to evaluate the uninsured claims through a full recovery process to recognize opportunities that might otherwise be overlooked. And so with that, let's go ahead and jump right in.
Great job, Tiff, showing that Weltman is prepared for technological difficulties with the paper copy. This biggest misconception, this is what we're going to spend our time today trying to address. It's simple, the premise. Uninsured does not mean uncollectible. It's an easy jump to take there, to just assume that since someone is uninsured, wasn't spending the money on insurance, that maybe there's no collectible person there. We need to move beyond that easy assumption and really evaluate the individual. By no means do we think that uninsured claims are straightforward. The truth of the matter is that most aren't. They present unique challenges, but that certainly doesn't mean that there isn't an ability to recover from those individuals. To be successful and make those recoveries, we need to form a better understanding of the entire recovery life cycle. And that is what we'll look at on this next slide. So this is the simple umbrella terms and stages of the recovery life cycle. Referral is where we get involved. You all, the insurance adjusters, make the decision, refer the claim to us, and then we jump into the second phase there that you see, the pre-suit resolution. That's a lot of investigation, so that we can build understandings of the people that we are trying to recover from. And that work lays the groundwork for the third stage of the recovery life cycle. If it's necessary, if we can't come to voluntary agreements with folks, then litigation becomes necessary. Obviously, with the investigative work that we do before we pursue litigation, we can make informed decisions about whether litigation is necessary. If it is, then we would commence litigation with the hopes of getting to number 4 that you see there, obtaining a judgment. We'll cover what exactly judgments mean later in the PowerPoint, but essentially a judgment is a piece of paper. It has no value, no inherent value itself, but it unlocks certain activities that can then happen that you will get to know more about in section 5 there of the post-judgment collection. And those are really the rights and abilities that we have that can lead to successful recovery. And that would be the ultimate goal. And that's what you see there as number 6.
Perfect. I agree completely. And so what we want to do with the audience today is change the way we think. So let's stop asking the question if there's insurance. Instead, what we should be talking about is where can recovery come from? And recovery can come from many of the sections of the life cycle that Tom just discussed. So in pre-suit negotiations, sometimes involuntary payments, payment plans, litigation, judgment enforcement. So we're looking at where can we get the recovery from not necessarily if there is insurance that's present.
The first letter of our acronym of the day is R. We need to recognize recovery opportunities. How do we do that? Well, we need to create opportunity. And to do so, we investigate and gather intelligence about defendants. What do they do? What kind of employment do they have? What are the avenues that would lead to successful recovery? Insurance is a piece of the equation, but it's just one single piece of the equation. Our job is to go beyond that and to conduct the sort of investigation that we need to discover these opportunities and to create. So recovery opportunity 1, this is the intelligence, and this is what we've been talking about. What are the things that we need to explore that tell us things that we need to see about a defendant that would ultimately lead to successful recovery? There's a list there: employment and income. Obviously, employment means that there is money to pay towards a judgment balance. Real estate ownership is important. If someone owns real estate, that brings in the potential to record a judgment lien against the real estate. Business interests obviously are another source of revenue for individuals and could create assets that we could collect against. Prior lawsuits and judgments obviously suggest that the individual might have other pre-existing obligations that could make it harder for us to recover. So when we talk about case-by-case approaches to determining collectability, obviously pre-existing lawsuits and judgments would be part of that equation. Bankruptcy history is much the same. If an individual has filed bankruptcy, it tells us that money may not be there to put towards a judgment, but it also tells us that certain debts might be included in the bankruptcy. Those would be things that we would investigate on our end and make decisions on a case-by-case basis about how we think it impacts our ability to collect. Commercial vehicles and equipment, again, assets that could make collection easier. So these are all things that we look at, that we explore, and that we kind of take a totality of circumstance approach to determining whether we think collectability is something that an individual presents. Recovery intelligence changes strategy. This is true. Not every uninsured defendant presents the same recovery opportunity. Again, case-by-case approach. Different individuals have different things going on at different times, and all of those things are very fluid, right? Circumstances change, and so we have to make these considerations. We have to considering all of the information you see here on the screen when deciding whether someone's collectible. Stable employment shows an income source. It shows us that we have a potential garnishment against wages, and that's a very effective recovery tool, obviously. Home ownership, again, that unlocks the possibility of recording a judgment lien. Judgment liens are a powerful tool. If someone wants to sell or refinance, then that lien comes into play, and you very well can have a full recovery. Again, business ownership we covered on the last slide. That presents additional assets and additional value that we could pursue once we have a judgment. Bankruptcy filings, again, that's a piece of the equation that we need to consider. It affects timetables of things, and it's definitely something that would inform our decision and what ultimately we suggest to you all when we're attempting to collect. And the same concept for judgments, like we've covered. The more judgments someone has, the more they're going to be stretched then to meet all of those obligations, and that's something that we review and make the determination on before we advise you all to proceed one way or the other.
And so, and those are all good points, Tom, and I'll just add for a second, and I know we are on to the next slide, but that's fine. You know, during this stage of the process, we're doing kind of two things. We're obviously trying to see if we can get recovery through like demand letters, things like that, maybe voluntary payments up front before we have to go to litigation. But if that doesn't happen, we're also, as Tom explained in detail, we're using our recovery intelligence to bolster the information we do have to be able to further analyze that file. So it's two things happening at this stage. Obviously, early recovery potentially could be great, especially if it comes and is cost effective, but then also bolstering and building the file to be able to properly analyze it to go into, you know, other steps later.
And when we evaluate a defendant, we shouldn't just evaluate the individual. We should evaluate the individual's trajectory and the things that could happen. As I mentioned earlier, collection is a fluid situation. Things change. They change day to day, month to month, year to year. Financial situations change, sometimes abruptly, for better or worse. And that's what we need to look at. If someone's unemployed today, sure, it's going to be difficult to collect, but they could be employed tomorrow, and it could be a consistent, well-paying job. It could be a renter turned into a homeowner, and then all of a sudden we have the ability to record a judgment lien. It could have, you know, a low-paying career, something that turns into more of a stable career, turns into owning a business, any of those things. And that all directly impacts how collectible somebody is. At the bottom there, the accident happened once, but collectability changes every day. That couldn't be more accurate. The accident happens once and judgment is entered once. Everything that happens after that is a very fluid situation.
And I think that's a great statement, Tom. And I think that if the audience, if you think back to your own life, how much your life has transitioned over the last 2 years. I mean, the claimant is the same way. They're having life transitions. And we're looking for, obviously, the claimants that are having life transitions in a positive way. That's what we're analyzing here. But to say that is so important. Collection is every day. It changes every day. And I think that's such a good statement for the audience to remember.
And again, some more examples that show how recovery outlook is impacted, right? Things can look pretty grim on a recovery basis one day. A couple months down the road, it can completely change. You can be unemployed, gain employment, you can be a renter turned into a homeowner, you can have no assets, and then all of a sudden you open a small business and accumulate assets. All of that changes, and all of those things are something that we monitor on a daily basis. It's what we do and what we serve you all in our attempts to recover is that we understand these things. We understand that times change and that assets and resources come and go. And we do our best to make sure that we stay on top of those things. And the cost of missing recovery opportunities, right? If we jump back to our original premise that we just assume that uninsured means uncollectible, we are missing opportunity. We're missing dollars of course, but you are missing that on a larger scale basis if you're making a simple decision that uninsured means uncollectible.
Okay. So now we are to our letter I, identify the right strategy. We spent the first part of today's presentation talking about recognizing recovering opportunities, and then Tom just explained the cost of missing them. But recognizing the opportunity is only our first step. Once we've identified a viable recovery opportunity, the next question becomes, how do you create leverage? And that's where many organizations stop. They look at an uninsured defendant and immediately think litigation probably isn't worth it. I like to challenge that thinking. Litigation isn't simply about getting a judgment. It's not even about getting the trial. Litigation is a recovery strategy. And when used appropriately, it creates information, leverage, opportunities that simply do not exist before a complaint is filed. So let's talk about litigation and how it can change your recovery. And so we have my cousin Vinny up here talking about this non-negotiable settlement offer. And that's going to push us right into litigation. You can't get a resolution. It's going to push us right into litigation. But litigation does not in itself automatically create a recovery. It's, as I said, strategic. The goal is identifying the right defendant, having the right timing, creating the right leverage, and the right resolution. And we'll talk about what that means to have the right resolution. Okay, so litigation most importantly changes a person's behavior. So defendants don't all of a sudden just want to take care of all of their responsibilities out of the goodness of their heart if they had not been doing that before. Instead, they do it because something has changed, and that is the lawsuit. So when you have the lawsuit, it's a lot harder to ignore. You have a process server that's coming to your home, trying to serve you with documents, legal documents in your presence. And if you're not there, serving them by tacking it on your door. So that lawsuit, that situation, that debt is directly in your face. So it's a lot harder to ignore. And it also now you're required to have some sort of responsive pleadings. So before, when you were getting the defendant or claimant was getting the demand letters, whether it was from the carrier directly or even the law firm, they could just ignore it. There was no requirement for them to file any type of response to that. So you never even knew what their position was. Now they have to tell you their position to some degree. They have to answer the complaint. So now there's deadlines to them actually telling you what their defense is, if they even have one. Then there's court oversight. So it allows mechanisms for the parties to be able to talk and see if they can resolve the case, but it also provides mechanisms for, again, getting out information. Courts will open what we call discovery, which is the exchange of information. And so that's overseen by the courts. The courts will obviously have time stop measures as far as that the person can just kind of drag it out. They're hoping that, next year things are going to look up for them. So they just want this case to kind of just be on pause until next year. The courts are not going to want to do that. They're going to want to get this case to resolution. So it allows someone else to have that timeline on us, and that works in our interest. And then every litigation has the risk of a judgment. If you're a defendant, you have a risk of having a judgment against you. And so that is realized by a lot of defendants, that maybe resolution is looking a little bit more favorable versus that judgment that may come down later down the line. And that gives you an incentive to negotiate. Let's talk about it. Let's try to avoid that judgment.
I don't think we can understate how important it is to commence litigation. It puts pressure on defendants, and I genuinely think that things get real from the time period that litigation starts. That's when they'll come to the table because they understand that now all these things that Tiff covered, that a judgment is on the line, that's when you can really get things accomplished and get to recovery.
Yes, very true. I think that's a great statement. That's when things get real.
Mhm.
So litigation isn't the objective, and it's not winning the lawsuit. As we said, it's leverage. And just as Tom said, it gets real at this point because now there's a real possibility of a judgment. There's a real possibility of a wage garnishment, frozen bank accounts, a driver's license suspension, court order appearances required. You may not be able to renew your tags on your vehicle. There may be liens on your property. You may incur costs of hiring an attorney. You may get a judgment that results in affecting your credit. So things are definitely getting real, and those are leverage points that we can use against the defendant to get a resolution that's in the best interest of the insurance company. So this is actually going to bring me to our first question that was presented to us. And I want to thank you all for presenting questions ahead of time here. Okay. How do you evaluate policy limits, actions, and determine whether it's worth pursuing additional recovery from the tortfeasor? And that's an excellent question because it's one we face regularly. When an insurance carrier has already paid its policy limits, and assuming they have not waived any rights you may have against their insured, because sometimes they will do that. But if that's not the case and you're able to pursue the actual claimant that they're insured, the question then becomes whether there's a realistic opportunity to recover anything beyond those policy limits from that individual. I don't make that decision based solely on the amount of the claim. I evaluate it using many of the same things we discussed today. So, does the defendant have a stable employment? Do they own real estate or business? Are there non-exempt assets? Is there another potential liable party? What are the anticipated costs of litigation? If the investigation suggests that a reasonable opportunity does exist beyond the policy limits, then litigation may be appropriate. If after a thorough evaluation there are no meaningful recovery opportunities, then accepting policy limits may be the most economical decision to make that's best for that file. The key is that the existence of the policy limit does not automatically end the analysis, just like insurance itself. The presence of insurance or the absence of insurance does not end the analysis. Just it begins the analysis. And so we want to talk about whether there is the ability to recover after that point. And so let's go on to litigation creates information. So we talked about the leverage that litigation provides us with. Now there's a kind of untalked about, unrealized benefit to litigation. So it's not about that judgment. It's not necessarily about the trial, but sometimes it's gathering information. So just think about the information that we gather. So when we file a lawsuit, we serve the claimant, we now have a good address for that person. So we confirm their address. We may be able to confirm their employment through discovery information. We may send out questions or admissions to get them to admit to certain things that we did not necessarily have prior to that point. We may be able to give financial information in some of those questions and find out maybe there was actually insurance, it just wasn't disclosed. So we can get some of that information as well, and whether there's any other parties that should have been identified but had not been identified until the point of litigation. And it allows us to clarify their defenses and, most importantly, evaluate their credibility. If the case does have to go on to trial, we need to know what the fact finder, whether it's the judge or the jury, is going to think about their testimony. And if they believe that this is a really trustworthy person, we better hope the insured is also a really trustworthy person too when they present as well, because that is something that the fact finder is going to have to determine. Every lawsuit should produce more information than you had before you filed it, and so that should be one of the important goals you have for that. Now, why do defendants suddenly get engaged? So before litigation, and I kind of went over this and I'll just do a recap, and I think it's a perfect time to integrate our second question. There wasn't a sense of urgency before litigation. After, the defendant has to make several decisions. Litigation creates, like I said, deadlines, risk of adverse things happening. There is pressure to settlement because of the adverse things, and financial exposure because, again, of the post-judgment activity. So we should recognize that litigation changes the environment in which negotiations occur. We're using it again as that leverage point. So a question was presented. So if I have a claim and it's only $9,500, I don't want to spend more money on litigation that I'll ever recover. How do we evaluate that? Well, a $9,500 claim may absolutely be worth litigating if the facts support it. Conversely, a $50,000 file may not be worth supporting if it doesn't have a realistic path to recovery. So we're not just looking at the amount of the claim. Again, I want you to change that thinking and analyze the file on a case-by-case basis, which all of you, many of you already said in the beginning. So we're looking at several factors. Okay, what's going to be an anticipated cost of litigation? What is likely, the likelihood of identifying an employer or other assets? Are there additional liable parties that we have not fully explored? Will we have the ability to use settlement and create leverage during the litigation process? What's the likelihood of us obtaining a judgment? So litigation isn't an all or nothing decision. It's an investment. It's just like an investment when you're weighing what's going to be expected on a return of a normal investment. So sometimes the answer is going to be yes, and sometimes the answer is going to be no. And I know that's a very lawyerly answer, but I hope that shows that we're analyzing each individual claim and not necessarily just one piece. Again, to recap, not just whether there's insurance and not just whether the file is worth $9,000 or $50,000 or $100,000. We're looking at more than that because, again, the goal is recovery in the most cost-efficient way.
To be sure, there have been plenty of $9,000 files that have resulted in greater recoveries than a $50,000 file. It truly does depend on the circumstances and everything that Tiff just covered.
Absolutely. So, and then I think we've kind of went over this a few times, but again, just to remind you, litigation, a successful litigation is not about winning a case, not necessarily about trying a case, not about obtaining a judgment. Instead, it is improving our recovery opportunity. So if you look at each step as how is this going to help me get to recovery, then you won't necessarily look at it as, okay, we got to make sure we get this judgment. Maybe that's what's needed in that particular case, but maybe not. If the presence of litigation creates leverage that allows you to get a resolution, then that was positive litigation. So, and that was successful. And that's going to take us into our next slide, actually, or our poll question, actually. So let's put our poll question up for everyone. Okay, and I'll let you all read it. So for a second, we may have to wake you all up a little bit, but that's okay. We have poll questions throughout to make sure. I know it's getting time for lunch. Okay, finding better leverage. Great, that's great. And then yes, finding insurance. Some people just definitely looking for that as the opportunity. So yes, we'll go ahead and go into all of those are great answers. So we'll go to the next slide.
Yeah, and back to our acronym, the S, it's for strengthening recovery through leverage. And a judgment is exactly that. A judgment is leverage. It unlocks a series of collection activity that then we can take to work towards recovery. And on that note, judgment isn't a goal, it's an asset. It's something that once we have, we then have other abilities that come along with it. And this is where we'll again try to change thinking. Instead of just being happy that we got a judgment, we should look at it as we acquired the set of rights that come along with the judgment. I mentioned earlier, judgment at the end of the day is just a piece of paper. It doesn't inherently have any value. It's what we do with it and the things that we can do with it that create the value. It doesn't guarantee payment, but it gives us the opportunity that if we can't secure voluntary payment, to try and get payment a different way. And already touched on it, but it's a mistake to just be satisfied with the judgment. We need to go beyond that, and we need to utilize all of the assets and tools that come along with the judgments to eventually recover.
And that's a great point. And I think we have a little visual that'll help a little bit here that we can show you. So again, the one thing that I hope you all remember from this section is the judgment is not the end of the road. It gives us, as Tom said, rights. And so every time we create something else in the life cycle of that recovery file, we're creating another wrong on the letter. And so sometimes we may need maybe half of the rungs on the ladder. Sometimes we may need all of them, but we have to handle that on a case-by-case basis. So we may start off with just a friendly reminder, and then we may get a little bit more aggressive and have a more stern demand letter. And then it may come over to counsel and have an attorney letter. Then we go into complaint, service, discovery, motion, judgment, collections, license suspension, recovery. Again, not all of the rungs are going to be needed. It's just increasing the pressure that we're putting on the defendant to want to resolve the file. And then obviously the best way to do that is to do as much as possible with as least as possible. So if you can get a recovery with just filing a complaint, then again, that was successful. If you need to take it to judgment, then that's appropriate as well too. If you need to engage in post-judgment collection activities, well, that's what you need. So it's going to depend on your particular file. So what does a judgment really provide you? So we've kind of talked about this, so I'll be brief. Again, it provides you with the ability to engage in wage and bank garnishment. So if we can't get a voluntary payment, then we can intercept those funds in the form of a wage garnishment, a bank garnishment. Here in Michigan, we can also do a state tax refund garnishment. We can also do post-judgment discovery as well. So ask about those assets in more detail, do a debtor's exam to get more information, have them produce their financials. We can do a judgment lien against their property, and so that will prevent them from being able to sell their property if they try to do that during the life of that judgment. And then also, once you have a judgment, you are negotiating from a stronger position. The judgment amount is fixed. So we're not talking about how much you should be paying necessarily. Now we're talking about how much you should be paying over time. So it's not the total amount that's owed, but how do you pay the total amount? And the judgment usually helps to get us to that particular point. And then again, we are able to utilize other collection activities, which Tom will talk about more, like driver's license suspensions and things like that. So we'll go to our little job aid here. As you see, we never shy away from a good job aid. So if we are looking at our decision tree, we just want to make determinations whether we need to monitor to see if these things improve, or if we can pursue the appropriate remedy. So if they're employed, we may be doing a wage garnishment. If not, maybe we need to monitor bank garnishment. If they don't, we may need to monitor, different things like that. So you're kind of going down your decision tree to see what is the best avenue for you.
Personally, I love the premise of this slide because it's so accurate. Persistence truly is a recovery strategy. We keep at it and we monitor all these things that you see on the slide there, because those are realities. Things do change, people's circumstances change, and as those things happen, recovery is impacted, and our ability to recover is impacted. There might not be much collectability at all one day, but a year down the road, who knows? And it's our job to continue monitoring these things and continue to try the collection activity, the forms of collection that we can take to try and take advantage of those changing circumstances. And one powerful tool that we have here in Michigan is the driver's license suspension. I mentioned that litigation makes things real for defendants will sort of suspending their driver's license. And that's for obvious reasons. We drive everywhere. We drive to jobs. We drive to family members. We drive to drop the kids off at school. When a defendant has a driver's license suspended, they really only have two options: either allow that to impact pretty much every facet of their life, or call us and work out a payment arrangement. And when they choose the latter, because they have to, that's when it benefits us and we recover for you all. And so getting to the last letter there of the acronym, what do we need to do? We need to evaluate, and we need to evaluate every file differently. It's a simple question just to ask if someone's uninsured. Don't do it. Ask instead where the next opportunity comes from. Where do we see an opportunity to recover from this specific individual?
Okay. Is there ever a point where we say we've done everything we can do and close the file? Absolutely. That is a case. And I'm sorry, I should have mentioned this was, I'm sorry, so we're right into it. This was actually a question that was posed to us in the registration. So the question was, is there ever a point where you say we've done everything and we can close the file? So the answer to that is absolutely. In fact, there is a time when we should stop pursuing, and a time to continue to pursue. And we hope that you pulled away that analytical thinking regarding an uninsured file. And so we hope that you utilize these ways that you can rise tomorrow. Now, I will readily admit that there's not 5 ways here. but we are going to give you ways that you can rise. So again, we want to remind you that it is recognized. Don't let the absence of insurance in your recovery analysis. Again, gather the information that will change your recovery strategy, not just your file notes. And then you want to strengthen, use litigation and post-judgment remedies to, again, create leverage, not simply obtain judgments, and evaluate. Continue reassessing every opportunity as the defendant's circumstances evolve. Every uninsured file deserves the question, where is the next recovery? And so we hope we utilize that one as your last walk away, your 5th walk away of every uninsured file deserves the question of where's the next opportunity. We hope you don't close it without you being able to answer that question.
We have one more poll for you all, so we will get that on screen.
Uh-oh, and I think we may have lost everybody.
Yeah, seems like no one wanted to be the first answer.
Right, exactly.
Very good.
Okay. So where is the next recovery opportunity? Great. And then there are also, yes, cost, is litigation cost effective? You're always going to evaluate that too. And does the defendant own assets? Absolutely. Those are things you want to consider. But before you walk away, just make sure at the end of the day, you can find your next recovery opportunity, and make sure that you do ask that question as well.
And so with that, I want to take a second here to thank you all for attending. We appreciate it. We hope that you took something away from the session, that you can now rise. This was another great episode of the Subro Scoop. We appreciate you all being here. If you did submit a question and we didn't get a chance to answer it, we will certainly get to that and follow up with you directly. We do not want anyone's questions to go unanswered, so we will make sure that they do not. Couple things, make sure you're following us on social media if you enjoyed this content and you want more like it. We're on all the platforms, TikTok, LinkedIn, Facebook, X. Just search Weltman and you should not have a problem locating those pages. Also, if you enjoyed this content, make sure that you keep an eye out for upcoming webinars. We cover all sorts of topics. And we think that a lot of it's pretty helpful. We hope that you do as well. So keep an eye out for those things as they come along. And then finally, we would love to hear from you all. Tell us what we did good, what you hated, tell us it all. We are constantly trying to improve these webinars so that you all, the attendees, feel like you're getting something out of it. That is the goal. With all that, thank you again. And hopefully see you next time.
Thank you all. I just want to add just one last closing comment that, again, feel free to reach out to us, even if you have questions that are not necessarily geared toward any particular presentations. We do get quite a few questions from clients, over time. So feel free to call us or email us, and that may spark a new presentation. We're always looking for what's on the pulse and the heart of the subrogation industry. So if there's situations you're encountering that are difficult or challenging, let us know, and maybe that's something that will be the next webinar. So feel free to reach out to us, and we appreciate you all being here and hearing our thank yous, because that means you made it through the entire presentation. Thank you so much.
Thank you.